I wondered this morning how many of you are students of our Constitution. Raise your hand if you're a student of the Constitution. I should see every hand in the room up. You're all students of the Constitution, but I want to take you a step beyond being just a student of the Constitution. I want you to become a scholar of the Constitution. That is, you know the Constitution better than 99% of the people in the country. And you're already on the way, because I dare say that this week, if you compare yourselves to the rest of Americans, you have spent more time thinking about and reading and studying and discussing this Constitution of the United States as well as the Word of God than probably 95+% of the people in the United States. You know, we're not going to restore our constitutional republic unless we have scholars in which book? The Bible and the Constitution. So we're going to talk about an issue that is of interest today because there's a big debate taking place in our country regarding what we call anchor babies. What in the world is an anchor baby? Well, look at this little cartoon here. You know, two illegals rolling into shore to the shores of America, the shores of freedom, and throw out the anchor, because if we can get this anchor sunk in the soil of the United States, we can stay permanently, and we can bring our family, friends, and everybody else from our home country and all that. Is it true that this is what that anchor baby idea is ensconced in our Constitution? Now, President Trump did the right thing after his inauguration to 2025. One of the first things he did was he declared that individuals born in the United States will no longer automatically receive citizenship if their parents are in the country illegally. Yes, or even here legally, but on a visa basis or a temporary visa basis, or here as college students or whatever reason they're here. If the parents aren't citizens, the child does not automatically become a citizen by being born on the soil of the United States. However, the Supreme Court or courts in general have been debating and fighting with Trump on this, and the Supreme Court has made kind of a weak, wimpy, limp-wristed ruling here. The Supreme Court recently ruled that federal judges have limited authority to issue nationwide injunctions against policies like Trump's executive order on birthright citizenship. However, the court did not rule on the constitutionality of birthright citizenship. They wimped out. They refused to face the tough issue and say, what does the Constitution, what does the 14th Amendment actually mean? And so I want to invite you this morning and ask you this question. Are you smarter, that is, are you more constitutional than the Supreme Court justices sitting at that highest court in our land? And I want you to be better than them. I want you to be smarter than them. I want you to be a better constitutional scholar than these supreme people who wear black robes. I say other things about them, but I won't. So if you're pregnant, if your cow is pregnant, let's put it that way. Your cow is pregnant, and your cow breaks through a fence on the border of my property, and your cow comes onto my property, and your cow gives birth on my property, is the calf now mine because it was born on my soil and not on your soil? What do you think? To whom does the calf belong? It doesn't belong to me, does it? It belongs to the owner when it broke through the fence to my property. So the owner of the cow is the owner of the calf born of the cow. Now that's obviously an illustration, but it's the same principle with this issue of birthright citizenship. You know, Mexico has actually gotten involved in this. There's a little cartoon there, squat and drop. Should not make anyone an American. Squat and drop doesn't do that. Well, anyway, a group of illegals, parents here in the United States, in the state of Texas, are suing the state of Texas because their anchor babies weren't immediately awarded birth certificates by the state of Texas. Because Texas says, wait a minute, these children, just because they're born on the soil of Texas, doesn't make them citizens of these United States. And so, actually, Mexico, the country of Mexico, got involved in this lawsuit. And they said, and I'm quoting their amicus brief to the court in Texas, the denial of birth certificates to U.S. citizen children, notice what they're calling these children, born to immigrant parents, not only jeopardize their dignity and well-being, but could threaten the unique relationship between Mexico and Texas. Notice it says they're calling these babies born on the soil U.S. citizens, even though that is not the case, we'll see. And the amicus brief also claims that denying the children U.S. birth certificates also blocks their claims to Mexican citizenship. Notice what they're claiming. This baby has dual citizenship. both in the United States and in Mexico. And they go on to say a child born to Mexican parents has the right that must somehow show proof of identity. And Mexico claims that infringing on this is a violation of international law. So if Texas won't issue them birth certificates, they're saying you're a criminal organization in violation of international law. The amicus brief also indicates that Mexican children born in the U.S. are eligible for Mexican citizenship. In the 1990s, Mexico changed its citizenship law to allow dual citizenships. And it did so to permit Mexicans residing in the U.S. to exercise dual citizenship and vote both in Mexico and in the United States. Do you think that's what our founders wanted? People who had dual citizenships and allegiance to two different countries? No. In fact, if you look at the actual oath taken by someone who's naturalizing, becoming a citizen of the United States, they have to reject all such claims of dual citizenship. But I understand more than half of Congress, I could have that number wrong, but more than half of Congress are dual citizens. Wait a minute, is there a problem with that? If they're dual citizens and they're voting as Congress, who are they voting for? The United States or the other country that they are also a citizen of? Wait a minute, these people, I would label them traitors to the United States. It should be illegal for anybody to have dual citizenship in the United States, let alone a U.S. congressman or senator. You know, years ago when Trump was first running for the presidency, he had this debate with Jeb Bush over this exact issue we're talking about, anchor babies, American-born children of what they call here, this is ABC's language, you know, they call them undocumented immigrants. Now, they're not undocumented immigrants. If they're here illegally, they're lawbreakers. They have broken into our country, just like that cow broke across my fence onto my property. The cow doesn't belong there, it belongs on the other side of the fence. And so we need to consider this from the standard of how you look at all of the Constitution. When we examine the Constitution, we want to understand the thinking of our founders when they wrote the words. What did they say these words meant? Not what somebody 200 years later says these words. What did the founders say these words meant? Now, this particular thing is to deal with the 14th Amendment. So it's not actually our founders. It's one of those amendments that took place after the war between the states. Those Reconstruction Amendments, the 14th Amendment. I want to this morning examine that 14th Amendment in both the U.S. and House, the U.S. House and Senate, the debates they had. I want to explore those debates which took place in both houses prior to the final approval. And I want to investigate Supreme Court litigation, a case that came before the Supreme Court to deal with this question of birthright citizenship as it relates to the anchor baby issue, and how the court's opinion connected to the meaning of the assigned text of the 14th Amendment by those who drafted that language with Congress, not somebody hundreds of years later. So it's interesting that even Newsweek got the message. And this is the way, look at the date there, 2010. Newsweek insults Obama as an anchor baby. Wow. We heard earlier this week, if you were catching the details, that there's cities and towns and villages in Kenya celebrating themselves as the birthplace of Obama, right? Okay. Wow. And so Newsweek actually was expressing the truth, but then they were, people were pillaging them for, oh, how dare you say that he's not legitimately an American citizen. He was not, which means actually he was not one who is legitimately president of the United States, as Hal pointed out last night. So let's look at what our framers thought about how we should interpret and understand the Constitution. James Madison, often called the father of our Constitution, said, if the sense in which the Constitution was accepted and ratified by the nation be not the guide in expounding it, there can be no security for a faithful exercise of its powers. So we've got to go back and understand what the people who wrote it understood it to mean when they wrote it. So with the 14th Amendment, it means we need to go back and understand what the crafters of the 14th Amendment meant when they codified that into law. Thomas Jefferson also famously said, the Constitution on which our Union rests shall be administered by me, this is when he was president, by me, according to the safe and honest meaning contemplated by the plain understanding of the people of the United States at the time of its adoption. So how did the people who wrote it understood it? How did the people who adopted it, the people of the United States, understand what it actually meant? It is we the people and those whom we elect that need to step back away from making our own interpretation and say, what did those who ratified this actually mean? And Thomas Jefferson, he said this, on every question of construction, that is how we understand the Constitution, let us carry ourselves back to the time when the Constitution was adopted. Recollect the spirit manifest in the debates, and instead of trying to what meaning may be squeezed out of the text or invented against it, conform to the probable one in which it was passed. So our founders are very clear about how, as we study the Constitution, how we are to understand its meaning. Now, when we come to the 14th Amendment and this issue of anchor babies, these are the 6 critical words that must be understood and must be interpreted properly. It says this: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. Notice the critical words there, and subject to the jurisdiction thereof. That's an extremely important qualifying phrase in determining who, born in this country, either is a citizen by birth or is not a citizen by birth. This is the jurisdiction phrase, and it's absolutely essential to understand in the phrasing of the 14th Amendment. Now let's look at the debates that took place as the 14th Amendment was passing both through the House and then through the Senate before it went on to the states to be ratified. The Senate debate on the 14th, the ratification, makes it clear that the Citizenship Clause proponents were very careful in how they crafted the language to preclude any automatic grant of citizenship based only on birth within the territory of the United States. Let's look at some of the words. They were well aware that there was a blanket grant of birthright citizenship, and that was not consistent with the American tradition, and that would lead to a demographic transformation in the event of high immigration level. And to prevent this, the senators included this jurisdiction phrase that we just looked at, those 6 words. And the floor debates reveal they were concerned, and it also reveals their view of how far birthright citizenship should extend, if at all. Primary concern of the amendment's proponents was the extension of civil rights to recently freed slaves. That was the whole purpose of the 14th Amendment. The slaves had been freed, 13th Amendment. Now the slaves were being declared citizens by the 14th Amendment, and the 15th Amendment was going to grant them the right to vote. So these 3 fit together, and their purpose is clear. It's dealing with the freed slaves. Senators feared that the state legislatures would assert that not having been born U.S. citizens, slaves were not born citizens, then that the states would put a fence around them basically and say you cannot become citizens even though emancipation has made you a free man, it doesn't make you a citizen of that individual state. And so to forestall that denial of citizenship to freed blacks and to overturn Dred Scott, which is a Supreme Court decision of horrible proportions, to overturn that explicitly, this was the purpose for those who were ratifying and drafting this proposed 14th Amendment, and why they put this citizenship clause in as well. Now, the one who introduced the proposed language that we're looking at this morning was Senator Jacob Merritt of Howard of Michigan, and he stated this, quote, he believed the citizenship clause was simply declaratory of what I regard as the law of the land already, that every person born within the limits of the United States and subject to their jurisdiction is by virtue of natural and national law a citizen of the United States. He went on to say specifically whom he considered that natural and national law excluded. Now here's people he said are not part of that deal. This will not, of course, include persons born in the United States who are foreigners, who are aliens, we could say illegal aliens, or people who are even here legally. They've got a permission to be here with a visa. So neither foreigners, aliens who belong to the family, or those who belong to families of ambassadors or foreign ministers accredited and so forth. So we say if somebody's here, whether they've entered our country legally or they're here illegally, and they have a baby while they're here, that baby does not become a citizen of the United States. This is on the floor debates in the Senate as they were proposing the 14th Amendment. And so if you want to be very clear as a constitutional scholar, you say, how should I interpret the 14th Amendment? Should I listen to Senator Howard? Or should I listen to some lawyer in a black robe today sitting behind the bench in the Supreme Court. Who should I listen to? Well, of course, the people who ratified this. These are the people who told us exactly what the 14th Amendment means. Now, an illustration of how this works is the question of American Indians. You see, the Indians in their tribes are actually in their nations. There is the Sioux Nation. There is other nations within our nation. They're within our territory of the United States. But notice how they phrase this regarding Indians. Howard pointed out, Indians born within the limits of the United States and who maintain their tribal relations are not, in the sense of this amendment, born subjects to the jurisdiction of the United States. They are regarded as, and always have been in our legislation and jurisprudence, as being quasi-foreign nations. The Sioux Nation is not the American nation. So if a person is born and by the way, this was changed later by the Supreme Court, but at the time, this was the case, that if you were born in the Sioux Nation, you were part of that nation. They were your jurisdiction was them and not that of the United States. It is clear, Edgar Cowan, the senator from Pennsylvania, it is perfectly clear that the mere fact that a man is born of the country has not heretofore entitled him to the right to exercise political power. Notice he's getting to the real point of the matter. If you are born and become a citizen by birth in the United States, that grants you political power. Now, I know some of you are not yet 18, right? But you will be turning 18. You could probably calculate for me in a second here how many years it would be till you turn 18. When you turn 18, you're all of a sudden granted political power in this country because you're a citizen of this country. If somebody else comes in at age 17 who's not here legally and suddenly turns 18, should we grant that person political power? After all, they've broken the laws of our country by breaking into our country. Or if they were born here of parents who illegally came into the country, does that automatically grant them citizenship, which is to grant them political power? You see where this goes. And back here when they were debating the 14th Amendment, they understood the implications of this. And he said, I have supposed that it was essential to the existence of society itself, and particularly essential to the existence of a free state, that it should have the power not only of declaring who should exercise political power within its boundaries, but that if it were overrun by another, a different race, it would have the right to absolutely expel them. He got it right. If you don't have the power to expel them, then you lose the power to control your own country. These men were wise. He continues, I do not know that there's any danger of many states in this union. There is any danger to many states of this union, but it is proposed that the people of California are to remain quiescent while they are overrun by a flood of immigration. This is talking back 1860s. All kinds of immigrants coming in, oversweeping the state of California. And he said, are they to be immigrated out of house and home by the Chinese? That was the major immigration at the time. I should think not. Is it not supposed that the people of California, in a broad and general sense, have any higher rights than the people of China? But they are in possession of the country of California? And he continues. And if another people of different religion, of different manners, and of different traditions, different tastes and sympathies are to come there and have the free right to locate there and settle among them, and if they have an opportunity of pouring in such an immigration as in short time will double or treble the population of California, I ask, are the people of California powerless to protect themselves? As I understand the rights of the states under the Constitution at present, California has the right, if she deems it proper, to forbid the entrance into her territory of any person she chooses who is not a citizen of some one of the United States. Again, these men had it. They understood exactly what the issue was. That if you allow unchecked immigration under Biden or even Obama, unchecked immigration will sweep over and change not only the texture and culture, it will change you politically. You will be transformed into whatever it is that's coming in. What are they coming in for? We know they're coming in for a welfare check. Free housing, free food, free medical, free education. They're coming in to plunder us, to take from us who are citizens here already. And obviously that's going to drastically change the complexion of our country. And he's saying the people of California as a state could exclude whoever they chose to exclude. Senator Doolittle said, citizenship, if conferred, carries with it a matter, of course, the rights, the responsibilities, the duties, the immunities, the privileges of citizens. For that is the very purpose of this constitutional amendment, to extend in the Constitution, as the Founding Fathers adopted it, they excluded the Indians who are not taxed, not enumerated them, indeed, as part of the population upon which they base representation and taxation, much less did they make them citizens of the United States. So he's talking here about those Indian nations. Let's say the Sioux Nation. If somebody's born in the Sioux Nation, when the census has taken place, they are not counted. And therefore, their representation in the House of Representatives does not take place, and the taxation portion does not take place because they're not counted as part of those who are counted as the citizens of the United States for representation in the House of Representatives. Doolittle is followed by Senator Lyman Trumbull of Illinois. He was the chairman of the Judiciary Committee at the time. He said, it's very clear to me that there's nothing whatsoever in the suggestions of Senator from Wisconsin. The provision, he's the one proposing the 14th Amendment provision here. The provision is that all persons born in the United States and subject to the jurisdiction thereof are citizens. That means subject to the complete jurisdiction thereof. Now, does the senator from Wisconsin pretend to say that the Navajo Indians are subject to the complete jurisdiction of the United States? And the answer, of course, is no, by no means. We make treaties with them because they're another nation. It cannot be said of any Indian who owes allegiance, partial allegiance, if you please, to some other government that he is subject to the jurisdiction of the United States. It's only those persons who come completely within our jurisdiction, who are subject to our laws, that we think of making citizens. And there could be no objection to the proposition that such persons should be citizens. Notice what he's saying there. If a person wants to be a citizen of the United States, then they're expressing they want to be in subjection to the laws of the United States. What if somebody comes in here illegally? What have they expressed? Are they in subjection to the laws of the United States? No, they're in rebellion against the laws of the United States, which is why I rightly say what we've experienced, at least in the last 4+ years, is an invasion of an enemy force designed to destroy us. They're invading us because they're not obeying our laws, and they have no intention of obeying our laws. Like I said, they come in simply to plunder us. Then from my state of Maryland, Reverend E. Johnson said, now all this amendment provides is that all persons born in the United States are not subject to some foreign power. For that, no doubt, is the meaning of the committee who have brought the matter before us, shall be considered as citizens of the United States. I am, however, by no means prepared to say, as I think I have intimated before, that being born within the United States, independent of any new constitutional provision on the subject, creates a relation of citizen to the United States. In other words, being born on the soil does not make you a citizen of the United States. And very clearly, Senator Johnson goes on to quote from the Civil Rights Act, which had passed before the 14th Amendment, 1866, that had just passed, and he considered that its wording, the Civil Rights Act, better expressed what the citizenship clause was meant to achieve, that is in the 14th Amendment. So he's saying, look at this piece of legislation we already passed. This is the meaning of what we're talking about here in the 14th Amendment, that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens. So when we look at all of these, it's very clear what the people who are ratifying the 14th Amendment, what they meant and what they intended, and they never intended anchor babies. They never intended this birthright citizenship idea that is so common in our day. And the Supreme Court in litigation has never held that the citizenship clause of 14th Amendment automatically confers U.S. citizenship on all children born within the territory of the United States. They have never made that decision. In fact, they have avoided that decision judiciously, it appears to me. But there are two major Supreme Court cases. One in which they got it right, that is, they were in tune with the 14th Amendment ratifiers, and one where they got it wrong. I'm going to look at the one where they got it right because that's the one you need to understand. Most important cases, 1884, the case of John Elk, and the 1898 case of Wong Kim Ark. And there's dissenting opinions on that concerning the opinion to the meaning assigned to the text of the 14th Amendment. This second one, Wong Kim Ark, they got it wrong. because they adopted the wrong thinking and they did not reference the people who ratified the 14th Amendment and what they said. They ignored what the people who said what they meant by the 14th Amendment. The John Elk case is the one that they got it correct. Let's look at that case. What it was is John Elk was an Indian born of an Indian tribe subject to the jurisdiction of his tribal nation, okay? And then later he wanted to become a citizen. He wanted to vote. He didn't actually go through any citizenship process. He just wanted to vote. And he showed up to vote and he said, "You're not qualified to vote." He said, "Well, I was born here." No, you're not qualified to vote because you were not born subject to the jurisdiction of these United States. So he fought it and took it all the way up to the Supreme Court in 1884. And the decision by the Supreme Court, the evident meaning of the jurisdiction phrase is not merely subject in some respect or degree to the jurisdiction of the United States, because if you think of it, somebody coming here on vacation, they get a proper visa, they're here legally. Are they subject to the laws of the United States when they drive down the road? Yeah, they are. So they can be pulled over and they can be given a fine even though they're not here as a citizen. They're subject to the laws, but they're not completely subject to the jurisdiction of the United States, only to those laws that relate to them as a visitor here in the United States. Notice what he says, but they must be completely subject to their political jurisdiction. And owing them, so a citizen from Sweden, say, comes here, they owe their home country, Sweden, where they are a citizen, they owe them direct and immediate allegiance. Indians born within the territorial limits of the United States, although in a geographical sense born in the United States, are no more born in the United States and subject to the jurisdiction thereof within the meaning of the Citizenship Clause, that's in the 14th Amendment, than the children of subjects of any foreign government born within the domain of that government. So if we have an ambassador that's representing the country of Sweden, for example, here in the United States, and the wife gives birth to a child, that child is subject to the jurisdiction of which government? Sweden, not the government of the United States. That child is a citizen of what country? Sweden, and not the United States. And the Supreme Court was very clear on this. They went on to say the opinion makes clear that the status of the parents of the child born within the territory of the United States determines whether or not the child is eligible for U.S. citizenship. To qualify the child for citizenship, his parents must be completely subject to the jurisdiction of the United States and must owe direct and immediate allegiance to the United States. In other words, they must be citizens of the United States. And by the way, we mentioned last night, natural-born citizen is a qualification for president. Technically, our founder said natural-born citizen means both parents, both father and mother, are both citizens of the United States at the moment in time that child is born. Anybody know the citizenship of Obama's father? Okay. Kenya. Was he ever a citizen of these United States? Never. Therefore, according to our founder's standard, he was never legitimately the president of the United States because he was never a natural-born citizen. Thank you. Now, the Elk v. Wilkins decision or opinion goes on to say the obvious corollary to being completely subject to the jurisdiction of one nation and owing it direct and immediate allegiance is that one can have no conflicting obligations to another. That is, you can't pretend to be a dual citizen. In Elk, the competing sovereign to which John Elk was held to have disqualifying allegiance was his tribe. It was his nation. Even though he had renounced membership in the nation, the legality of Elk's presence in the United States was not an issue. He was legally here. His right to be in Nebraska was not disputed, but he was not a citizen based upon his birth. In the case of the illegal aliens, the illegality of their presence in the United States is not in dispute. We know that they're here illegally. They remain entirely subject to the jurisdiction of their home countries. The only nations to which they owe direct and immediate allegiance is their home country. By the way, I'm stepping out of the Elk and just giving commentary here on the issue. To reason that though breaking the laws of the United States by entering and remaining illegally, an illegal alien somehow transferred his allegiance from his home country to the United States is absurd. One does not pledge allegiance to any republic by entering it uninvited and flouting its laws through his continued presence. It is more absurd still to allege that by breaking into its territory, the illegal alien subjects himself willingly to the jurisdiction of the nation he invaded. It's completely contradictory. You can see that. The Supreme Court in Elk denied birthright citizenship to a man with far stronger links to America than any illegal alien, a man whose resident was in compliance with American law. The court did so on the basis of a common sense reading and application of the Citizenship Clause of the 14th Amendment, one that gives due weight to its jurisdictional phrase and reflects the understanding of its drafters. There's no latitude in that correct interpretation for any grant of U.S. citizenship to U.S.-born children of illegal aliens or even those who are legally here. Birthright citizenship, 14th Amendment, is misinterpreted, misapplied in that case altogether. So today, sadly, the federal policy has been, and this is now in question as Trump has challenged it, the courts have responded, and there's a back and forth going on. They confer currently automatic American citizenship on any child, with very few exceptions, any child born to illegal aliens in this country. And the legal status of the parents has been considered irrelevant. Who cares about the parents? The child was born on the soil, therefore they are a citizen. And we're told that we must accept that baby born to foreign parents in 5 minutes after they've crept over the border illegally, just as a baby born to parents who's been legally in the United States for 350 years. You see, we know what this is about. This is about a way to take down America and completely destroy our constitutional republic. You see, this new American, if that baby was granted citizenship, that new American's not the end of the story. His U.S.-born child becomes the anchor on the American soil that will permit the parents to stay. Because after all, if the parents had to go back home, how's this baby going to survive? Oh, the parents got to be there, of course. Well, then not just the parents, but then the minor siblings of that child are to remain, and later his grandparents and his aunts and his uncles and his in-laws and all the children that come along with this chain migration, not to mention friends, family, acquaintances from home that may follow them illegally. I had a friend whose daughter began dating against his will an illegal alien from Guatemala. And just come to discover that this illegal alien from Guatemala was from a certain village in Guatemala. And that entire village, except the most aged people in that village, had all immigrated and all formed a village outside of Baltimore. Every single one of them, except the most aged, were all there. And they were all there illegally. Against his wishes, of course, she married. And again, that's one of the wicked things about the marriage license system we're currently under. The government granted a license for her to marry a man that the father would not grant the license for her to marry. So if the father of the bride says no, that should be the end of the story, but not with the wicked system of marriage license. But that's an entirely different subject. So let's consider the implications of this. The actual text of the 14th Amendment means anyone who breaks into our country, gives birth to a baby, both parents and baby are still subject to the foreign jurisdiction they're allied to, the country which they came from. The birth of the baby does not change the status of the parents, whose status in turn determines that of their baby, their offspring. Thus, anchor babies are a misinterpretation of the 14th Amendment altogether and a misapplication. So if your pregnant cow broke through the fence in my property and came onto my property and gave birth to a calf on my property, would that calf be mine? No. Belongs to the owner. Now that's a bit of a stretch, but it is an illustration of this principle. Somebody that breaks into our country, the baby they give birth to on our soil, that does not make them automatically a citizen of the United States. What I see happening here in America is spoken of in Scripture. And this is a prophecy spoken of by Nahum chapter 3 and verse 13. The gates of thy land shall be set wide open unto thine enemies. And this is what's happened in America as part of God's judgment, but also part of what the wicked have been doing in our country. They, by design, are planning to destroy America. They have stated this. This is not a hidden agenda. It is very public. You can read about, and we can give you plenty of resources that you can see this. And they know that the only way to fundamentally transform America, wasn't there some guy fake president that said something about fundamentally transforming America? Yeah, he knew these illegal aliens were one powerful way to fundamentally transform America, and they've been about it. It's time for it to end, and I applaud President Trump for not only putting this forward, but you now know more than the Supreme Court of the United States, which seems not to want to touch this issue with a 10-foot pole. They had an opportunity this week, They turned it down, or last week, they turned it down. I said, no, we're not going to rule on that. We're not going to touch that. Well, there was one time that the Supreme Court got it right. Another time they got it wrong. So it would be proper for the current Supreme Court to resolve the issue. And all they got to do is go through what the presentation I gave you this morning. All they got to do is look at the words of those senators and congressmen as they put together the language of the 14th Amendment. They describe what that language actually means and how that language applies to Indians, for example, born within the Indian Territory. By the way, just a footnote, that was changed, and I think it was 1920, where legislation was passed by Congress that said every Indian born in whatever nation within our territory is immediately an American citizen. But before that, this was the truth, that they were citizens of their Sioux Nation or Iroquois, whatever nation it was they were part of, and they had to renounce that citizenship to actually become naturalized as a U.S. citizen. So you may have some questions. I know I've presented a whole lot of material, and this might feel like it's deep, but this is what it takes to be a constitutional scholar. You've got to look at what was said and understand the meaning of those who ratified these statements. So questions on your part? Yes, amen. Stand up so we can hear you better.
You said that if someone is here for just a couple weeks, maybe for vacation, and they have their kid here, they shouldn't be a U.S. citizen. What if they have a longer visa, like a longer term visa for 3 years or 5 years or a permanent residency card or something?
Until they become citizens, that baby should not be considered a U.S. citizen, I believe, by the standard expressed here of those who ratified or crafted and ratified the 14th Amendment. Excellent question. Yes, go ahead. Yes, the child can become a citizen. That's right. Yep. They can go through the process of naturalization. Yes. Stand up so everybody can hear you. Yeah.
The Wong Kim Ark ruling, how was that wrong?
Well, what they did in the Wong Kim Ark ruling, they did not use the U.S. standard of citizenship. They adopted the English standard. I thought we had a war with that country. And I thought we didn't want their system. You see, the King of England wanted as many subjects as he could possibly have. And therefore, any territory that was part of the English domain, the sun never set on the Empire of England. Any place in the English domain a baby was born, that baby immediately became subject of the king. We're not subjects of any king. We are citizens of a constitutional republic, which actually makes Obama a subject of the King of England, born on Kenyan soil. At the time he was born, Kenya was still under the power as a colony of Great Britain. So he's a subject of the King of England, and not, it's just crazy. But excellent question. Alex, yes.
So what do you think would be the best thing to do about, we've got now multiple generations of people who apparently became citizens illegally. Do we go back in time and start revoking citizenship, or do we allow like a grace period or an amnesty? How do we deal with it?
Excellent question. I believe we should grant an amnesty grace period in which they must go through that citizenship process. They've got to take the courses, they've got to do everything required to become a citizen of the United States, and then swear the oath. And by the way, and I haven't showed it here, but you look at the citizenship oath, it is extremely clear. They are renouncing all allegiance to any foreign power, potentate, any connection. Dual citizenship is denied. So yes, I believe, because we do have so many, it would be good to grant them a time where they have grace period. But if that time expires and they do not do the work towards becoming a citizen, I believe they should be expelled from our country because they're here breaking the law. Yes, young man, stand up.
What do you think about legal citizens marrying legal citizens in order to gain a U.S. citizenship?
Excellent question. Again, here's the issue of who grants the license for that marriage to take place. If the father of the bride grants the license, I believe that it is legitimate. That if a marriage is rightly entered into, not with a state license, but with the license of the father of the bride, then that person, whether the male or female, can become a U.S. citizen. But I believe also they should have to go through that process of naturalization. In other words, they should say, okay, you're here legally, and we accept you legally on the soil of our country, but you need to go through the process of naturalization and become a citizen of the U.S. Excellent question. Yes, young man, stand up.
How long does it take to do the U.S. citizen test, and what do you think would be a better process to become?
Yes, and those who have taken the opportunity with Victoria have been able to see what the citizenship test is like, and I think you told me that only one person so far has gotten 100%, is that right?
And she is, she's become a citizen of the United States?
She naturalized, and she does better than us who are born. Very good. So I believe that the process can be lengthy because, and perhaps our immigration laws need to be changed. It can take many years for that process to happen. I don't know the exact number of years. They do have to take a course, and I've examined parts of the course, and I've examined part of the question. I think one of the questions is, are we a democracy? Is that right? Yeah, I thought one of the, and we're not. And the correct answer, according to the immigration, is that yes, we're a democracy. So they've even got it wrong. So there needs to be a good course, and we offer a good course here on the U.S. Constitution. I would advise that adopted by the immigration naturalization process that would actually train them in our founders' view of law and government. I thought I saw another hand. Was there another hand? Yes. Stand up so we can hear you.
What about Israelis?
Oh, you mean the dual citizenship? Well, that should be not permitted. They either choose to ally themselves with Israel as a citizen of Israel or the United States. They should not be dual citizens. And you're right, I think there are many in Congress, which should make us very suspicious. If they're in Congress voting, who are they voting for? Israel or the United States? Or make it a little more bold. Let's say they were citizens of communist China, okay? Well, as a citizen of communist China and you're sitting in the Congress voting on bills, what in the world's going on here? Yeah, I think all of those people should be removed from Congress, and that they should be forced to make a decision and go through the naturalization process because they came in as a foreigner to our country because they allied themselves. And by the way, there was a foreigner who ran for president recently from Texas, of all places, Ted Cruz. He was a dual citizen between Canada and the United States. And when the Dallas Morning News exposed this, he quickly renounced his citizenship in Canada. It was like, wait a minute, he's running for the presidency of the United States and he's a dual citizen? Yeah, because he was born in Canada. Both his parents were Canadian. And so what's going on with that? So obviously the Americans in Texas aren't very savvy, but I guess the pressure was put on him and he quickly renounced his Canadian citizenship. But he's an illustration of how far someone might go, which also questions, is he a natural-born citizen if both of his parents were Canadians at the moment of his birth? What does that make him? Does that make him a natural-born citizen? No. He's disqualified for the presidency, but he was running for president anyway. Yes, sir.
So, my brother, my mother married someone from another country. He came here legally, had a green card, working visa. While he was in this country, he was applying for citizenship. Don't know if he ever got it. But his country went to war, and it's gone. So his country is gone. So then my brother was born. Then he turned out to be an absolute POS, and they tried to get rid of him. They used my brother as the anchor baby. They were able to get rid of that so that they were able to deport him. But he didn't have no country to go back to anymore. The new country that took place in that 7-year time period said, no, we don't want this guy back. So we don't know where this guy is anymore. We think he's still in the United States. We really don't know. This happened a long time ago. But now my brother is sitting here. You know, my mother is a United States born citizen for many generations. So he was born, from my mother, obviously, and he has citizenship. But from what I just, so you telling me that he shouldn't be a citizenship.
No. Let me correct that. If either parent is a citizen of the United States, then that child can be a citizen of the United States. But I believe at age 18, they need to make a decision. Are they going to be, say they had a citizenship, one parent was Israeli, the other was American. Okay, they need to make a decision when they come of age at 18. Am I going to become an Israeli citizen or a United States citizen? So I believe that is legitimate. They potentially are set up for U.S. citizenship provided one parent is a U.S. citizen. Now, if neither parent, obviously they don't, but if both parents are citizens, then they are a natural-born citizen and can run as president of the United States. Does that make sense? I know.
Makes sense, but I don't know that he's ever made a decision. I don't know if veterans ever pointed that out to him. But how would anyone know that?
Well, part of the problem is we don't have a system legally, which we should have, where that situation is dealt with very clearly, and it's like, okay, this child has a potential to become a citizen of either country, but at age 18, they need to make a decision. And at age 18, if they're going to be a citizen of the United States, they ought to go through the naturalization citizenship process. And by the way, I think Victoria illustrates this very well, that most American citizens don't know what our government is about at all. We all to force every 18, because civics isn't being taught anymore in the school, that every 18-year-old should be forced to go through an excellent course on the U.S. Constitution and take a test and pass the test and then go through the citizenship process where they affirm, I renounce all allegiance to any foreign country and my allegiance is to these United States. I know there's difficult situations because we have not followed what our founders and what those who ratified the 14th Amendment actually wanted. Are we out of time?
Yeah.
Okay.
I wouldn't be surprised if many in Congress would pass the test.
Oh, yeah, I'm certain of that because it's the voters who choose the congressman, and if the voters don't have the standard, then they're not going to hold the congressman to that standard. Yeah. Thank you all for your kind attention.